Florida Statutes Section 733.1051, limited judicial construction of will with federal tax provisions. Upon the application of a personal representative or a person who is or may be a beneficiary who is affected by the outcome of the construction, a court at any time may construe the terms of a will to define the respective shares or determine beneficiaries in accordance with the intention of a testator, if a disposition occurs during the applicable period and the will contains a provision that includes a disposition formula referring to the terms unified credit, estate tax exemption, applicable exemption amount, applicable credit amount, applicable exclusion amount, generation skipping transfer tax exemption, GST exemption, marital deduction, maximum marital deduction, unlimited marital deduction, or maximum charitable deduction, measures a share of an estate based on the amount that may pass free of federal estate tax or the amount that may pass free of federal generation skipping transfer tax. Otherwise, makes a disposition referring to a charitable deduction, marital deduction, or another provision of federal estate tax or generation skipping transfer tax law, or appears to be intended to reduce or minimize the federal estate tax or generation skipping transfer tax. For purposes of this section, the term applicable period means a period beginning on January 1st, 2010 and ending on the end of the day on the earlier of December 31st, 2010, or the day before the date that an act becomes law that repeals or otherwise modifies or has the effect of repealing or modifying Section 901 of the Economic Growth and Tax Relief Reconciliation Act of 2001. A disposition occurs when the testator dies. In construing the will, the court shall consider the terms and purposes of the will, the facts and circumstances surrounding the creation of the will, and the testator's probable intent. In determining the testator's probable intent, the court may consider evidence relevant to the testator's intent even though the evidence contradicts an apparent plain meaning of the will. This section does not apply to a disposition that is specifically conditioned upon no federal estate or generation skipping transfer tax being imposed. Unless otherwise ordered by the court, during the applicable period and without court order, the personal representative administering the will containing one or more provisions described in subsection 1 may delay or refrain from making any distribution, incur and pay fees and costs reasonably necessary to determine its duties and obligations, including compliance with provisions of existing and reasonably anticipated future federal tax laws. Establish and maintain reserves for the payment of these fees and costs and federal taxes. The personal representative shall not be liable for its actions as provided in this subsection, made or taken in good faith. The provisions of this section are in addition to and not in derogation of rights under the common law to construe a will. This section is remedial in nature and intended to provide a new or modified legal remedy. This section shall operate retroactively to January 1st, 2010. If you're interested in any of our services, please call 321-206-3603 or visit easlerlaw.com to book a consultation.